Good afternoon, everybody. It is 2 o'clock and 15 seconds, so we can start. This panel now is one that I think shifts now the focus over to principles 3 and 5 of the Nuremberg Declaration of 10 years ago that was already mentioned a couple of times. The title, The Forgotten Voices, Catering to the Need of Victims. Maybe a couple of points here. I think that the development of the participation of victims in criminal proceedings in an international setting has been exceptionally dynamic. I would say even more dynamic maybe in the past 10, 15 years than the development of international criminal law on the procedural or the subject matter level. Let's recall that the military tribunal here in these premises did not have any provision that would give victims a participation on their own right. Likewise, the pioneers of the 90s that really resurrected the entire idea of international criminal justice, the ICTY and the ICTR, did not provide for victim participation beyond their status as victim witnesses, as the President also already mentioned earlier this morning. However, already in the 90s, we did have discussions in many different fora and settings whether the ideas of punishment, what is criminal justice about? Is it just to bring the perpetrator to justice and protect the population through deterrence? Or is there also some more to it? These points were discussed, and the restorative and reparative value to the specific benefit of the large victim communities of international crimes beyond the idea of mere retribution has really gained a lot of traction. Now, since then, since particular also the tribunals, I think we've seen how the victim participation and victim as a right holder in the proceedings, be that participatory or be that also in terms of reparations, has become more prominent. Extraordinary chambers in the courts of Cambodia, Special Tribunal for Lebanon, Cour spéciale centrafricaine, Kosovo specialist chambers. The list is quite good, I would think. And then obviously the ICC with what I would think maybe the most complete victim participation and reparations system, and surely the most tested in terms of the courtrooms. And to say it with the words of the President, we're looking at an integral part of the international criminal justice system. So I think that we're true to these principles in the Nuremberg Declaration in having a victim participation panel or a victim-oriented panel. I just want to throw 3 challenges into the discussion for all of us to look into, maybe if we have the time for it in the next 90 minutes. The challenges that we're looking at is, and when I say we, it is the International Criminal Court, but I think any other court as well that deals with victim participation, is how and when do we reach out to victims? Each situation, country, each situation has its own challenges, security, but also how much participation is granted by the chambers. How do we ensure that these victims, once we have identified them, are actually properly represented in the courtroom, and how does the information get to them in the field? And finally, something that David Schäfer also said, how do we make the ICC reparations regime work, or any other reparations regime, because it's all about funds and where do these come from? I think in light of these challenges, it is my honor and pleasure to have such a powerful panel of experts in these fields that I will now introduce to you. And I shall start with Judge Anita Ušacka. Surely she doesn't need any introduction. She is one of the few judges that actually even spent 12 years at the ICC, part of the absolute pioneers. And Judge Ušacka did actually go through all judicial divisions, which is also something which I think is quite remarkable and gives her a very broad overview of the perspectives from all ends. She used to be the president of the appeals division for a term as well, and before that she used to be a judge at the Latvian Constitutional Court, and also she has an academic side to her activities, and that is she is a professor at the Department of Constitutional Law of Latvia University. I step to the far left for me, far right for you. Sarah Kasande, she's the head of office of the Uganda program of the International Center for Transitional Justice. She's an advocate of courts of judicature in Uganda. She has many years of experience working in the field of human rights and transitional justice, and very importantly, she also works closely with the International Crimes Division of the High Court of Uganda to support the establishment of frameworks that will ensure the effective investigation, prosecution of international crimes, and the protection of victims' rights. And finally, Fiona McKay, British lawyer, currently with the International Justice Program of the Open Society Justice Initiative, and until 2015, for pretty much the entirety of the existence of the victim participation and reparations section, she used to head that section at the International Criminal Court, and is therefore, if you want, the pioneer as to what this section has become and done. I myself am Philipp Ambach. I'm her successor. This is why I talked first, because otherwise you wouldn't have listened. So without further ado, I would give the floor to you, Judge, for the first notes. Thank you.
Thank you very much, Philipp, and I would like to say that I am very honored to be here in this wonderful courtroom and to share my experience with you. And I would like to start, of course, that everybody knows that Rome Statute provides one of the most advanced schemes for victims' rights in international criminal justice by way of victims' participation in proceedings and the forms of redress available to victims. This is one of the important challenges the court is facing. Today, I would like to return to the beginning of ICC. On 11 March 2003, I was one of 7 women and 11 men sworn in to serve as the first 18 judges of International Criminal Court. The inauguration was itself an event prepared with the kind of ceremony and elegance representative of what was considered to be truly historical event. I recall my wonder and excitement at meeting for the first time the 17 other newly elected judges of the court and the excitement we all felt in the beginning work of the court. The issue of victims' participation in the proceeding was one of the priorities from the beginning because actually there was not any similar experience available. One of the important tasks of judges was to draft regulations of the court, which were adopted by the judges on 26 May 2004, and which regulated victims' participation and reparation. Regulation 86(9), paragraph 9, established the victims' participation and reparation section of the registry. This unit shall be responsible for assisting victims and groups of victims. Simultaneously, Regulation 81 established an Office of Public Counsel for Victims for the purpose of providing assistance to victims. Later, in 2010, after first experiences in the proceedings, judges were very concerned about how victims of participation is happening. And I remember very well that Judge Fulford said that we created Frankenstein, which we need now to delete. So it was a special plenary session of judges in 2011. It was very hot discussions how to proceed further. And after this plenary, there were many changes in regulations of the registry. When the first trial against Lubanga started in 2005, the presidency approved 2 forms created by the Victim Participation and Reparations section of the Registry for Victims to request the participation in the court proceeding. These forms were very long and difficult to understand and to work with them. There were many, again, meetings and discussions how to improve these forms. Further, in 2005, a special working group was set up by the judges to prepare a concept for reparation of victims. Article 75 of the Rome Statute states that the court shall establish principles relating to reparation to or in respect of victims. And the working group worked on this concept and came to 2 possible choices. First choice was that principles of reparations should be established on case-by-case basis by the chambers of the court. The second approach, principles of reparations should be established by the plenary of judges or by the judges of trial division or by the respective chamber of the trial division. As you see, these 2 approaches are different, and here we see how 2 legal systems of civil law and common law clashes. And after many discussions, every judge submitted a memorandum, expressed her or his view on this issue, and at the end, the common approach was accepted. So a result of this approach was that different chambers came to different conclusions. It took time for appeal chamber to streamline, and it's still some contradictions in the decisions regarding of the victims' participations. Parallelly, the judges continued to discuss the question of victims' participation. From 6 to 8 July 2006, the judges went on a working visit to International Institute of Higher Studies in Criminal Sciences in Syracuse, where participation of victims in the proceedings and reparations of victims were discussed with prominent professors and professionals in the field. Later, these issues were important topics for discussions at the plenary meetings of the judges. If you look to the practice in this time, you can see that while the introduction of the right to participate represents a major shift away from introduction of the right traditional view of victims, in reality, the application process is time-consuming and resource-intensive. The large number of applications from victims has left the ICC struggling to keep pace and has led to the inability of victims to represent their views. The ICC has received hundreds of applications from victims who often live in remote villages, such as the Eastern Democratic Republic of Congo and Northern Uganda. These remote areas may also be entrenched in the conflict, making it difficult, if not possible, for applicants to travel to nearby cities to obtain proper identification cards or other documentation to be appended to their application. I recollect from my experience as judge at the pretrial chamber and the appeal judge that 366 victims participated in the case of Katanga and Gudula Chui, and the appeal chamber granted 30 victims out of 33 applications for new victims participate in Lubanga appeal against his conviction and sentence. When I prepared to come here, I just looked to my archive, and I found memo of Judge Cowell in that time when we discussed this issue, and it was a very long memo, and he worried a lot about what will happen when we will have trial with two accused like Katanga and Gudula, and 4 teams will represent victims, plus prosecutor and plus defense, how long time it will take and how money it will cost for the court. Later, of course, came other problems as problems with intermediaries. So after this historical excursion, little excursion, I would like now to turn to the question, where do we stand in the fight for the accountability and against impunity for international crimes? Between 2007 and 2009, the International Institute of Higher Studies in Criminal Sciences in Syracuse undertook a historical survey of world conflicts which occurred between 1945 and 2008. Later, other experts advanced this study. The experts who reviewed data compiled from multiple sources concluded that between 1945 and 2012, more than 313 conflicts took place throughout the world. These conflicts resulted in estimated 202 million deaths, which is much more than the number of deaths in the both world wars combined. Less than 900 of the perpetrators of international crime have been brought to justice, and amnesty law in 125 of 313 conflicts identified by the study were enacted to shield the perpetrators from justice. Some form of victims' reparation was only undertaken in 16 of 330 conflicts, involving less than 1% of victims. The preamble to the Rome Statute, for instance, contains the affirmation that the most serious crimes of concern to the international community as a whole must not go unpunished, and the determination to put an end to impunity for the perpetrators of these crimes. However, in reality, is that the ICC can only prosecute a small fraction of perpetrators of atrocity crimes. It is crucial, in my view, to have national prosecution to fulfill the mandate of accountability. It is clear, though the most conflict crimes are committed by significantly more individuals than are prosecuted by ICT and other international courts, if there is to be accountability for the crimes committed, the vast majority of prosecutions must be occurred in national jurisdictions. Thank you.
Thanks so much, Judge, for these very insightful remarks, also the historical view of how the judges have been tackling so many different problems and the rather concerning figures that you also gave us. Now over to Sarah with the more general picture from your vision. Thank you.
Thank you, Philip. Good afternoon. It's an honor to be here and to join this group of eminent panelists. I will be looking at the role of victims in the international criminal trials. The international criminal justice system has evolved from the exclusive focus on holding perpetrators of international crimes accountable to include the vindication of victims' rights and give victims a greater role in the criminal proceedings. Indeed, the ICC's aspirations seem to go beyond the traditional retributive scope of international criminal law to include aspects of restorative justice. It has created a new culture of victims speaking and having their interests considered during criminal proceedings. It goes without saying that victims' central interests in criminal proceedings is that the outcomes of such proceedings will lead to the identification, prosecution, and punishment of those who have victimized them. The participation of victims in criminal proceedings contributes to the legitimacy and credibility of those trials. For a long time, victims were at the margins of criminal proceedings. They were and are still seen in many jurisdictions as instruments of the prosecution. For example, the ICTY and ICTR did not recognize the specific rights of victims to participate in the proceedings. The role of victims was limited to testifying in the case, if so asked by the parties, thus restricting their chance to tell their stories to evidentiary needs. The Rome Statute makes a departure from this practice. Under Article 68.3 of the Rome Statute, victims are permitted to participate in criminal proceedings when their personal interests are affected. They are entitled to have their views and concerns presented and considered at stages of the proceedings determined to be appropriate by the court and in a manner which is not prejudicial or inconsistent with the rights of the accused. The victim participation scheme at the ICC goes beyond merely assisting the court to clarify the facts or punish perpetrators of crimes. It ensures the satisfaction of victims' interests and the right to truth. In addition to participation, upon the conviction of an accused person, victims have the right to obtain reparations for harm suffered as a result of the commission of crimes within the jurisdiction of the court. The implementation, obviously, of these reparation orders are by the Trust Fund for Victims, which also implements victim assistance programs, as was mentioned this morning. Uganda, for example, is one of the contexts where the Trust Fund for Victims has implemented a number of victims assistance programs. I will be examining later on the effectiveness of these programs. Another aspect that has been crucial to the participation of victims is outreach. The ICC's outreach program has enabled victims to not only follow the proceedings, but also given them an opportunity to engage with the court and share their expectations of the proceedings. Now, the victim participation regime at the ICC has also had a positive downstream effect on national criminal proceedings. For example, in my country, Uganda, our International Crimes Division has incorporated the victim participation regime similar to that of the ICC in its own rules of procedure and evidence. In the case against Koyolo, the pre-trial judge has outlined a number of guidelines that will ensure the meaningful participation of victims during the trial. Again, when we look at, for example, the extraordinary African chambers within the courts of Senegal, we have over 40,000 surviving victims who were directly represented during the trial of former Chadian dictator Hissène Habré. So we see that the ICC norms on victim participation are not just limited to ICC, but are having meaningful impact at different jurisdictions. Now, very briefly, I'd like to look at the nature of victim participation as enshrined within the Rome Statute. The paramount criterion that is laid out in Article 68.3 is for victims will only participate if their personal interests have been affected by the crimes that are within the jurisdiction of the court. The ICC's jurisprudence, as the Justice has already mentioned, has laid out elaborately how this participation will be rolled out. And they've also stressed the modes of participation, which include being notified on the same basis as the prosecution and the defense of all the public proceedings before court, to have access to all the public rulings and public decisions, to have access to the transcripts of the hearings, and to also have access to the available public evidence. The legal representatives for victims have an opportunity to make opening statements and also to deliver oral submissions in accordance with Rule 91.2 of the Rules of Procedure, subject to the authorization of the Chamber, having determined that the manner of participation is not prejudicial or inconsistent with the rights of the accused and the rights of the accused to a fair and impartial trial. We've seen that legal representatives of victims also have a right to question witnesses and experts who are called to testify before the court. They have a right to introduce evidence during the trial or different stages of the proceedings. All this is well and good, but what does it really look like at the ground? And this is what I'd like to focus on. Whereas we've seen at a normative level there's been this growth of victim participation, and the court has congratulated itself on this, there still remains a number of challenges to this. First is the application process. Today, the court has made progress in simplifying the application process, in simplifying the forms, but there's still a lot that is lacking. In Uganda, for example, there was limited information that was shared with the affected communities about the application period and what was required to apply. The application period ran from May to October 2016, and it was closed off. Therefore, a number of victims were excluded from this process. Yes, there are 4,100 victims who successfully applied to be part of the proceedings, but when you go back to the communities, a significant number were excluded because of this strict time frame, and there are questions as to whether, there are questions as to whether the court will open this up. Then the other, of course, goes without saying, the inadequate information to the victims about, again, as I mentioned, the eligibility requirements, and also the programs that are being implemented by the Trust Fund for Victims, the victims assistance programs. There's very limited information about this to the communities, and to date we still remain to see to what extent victims could be involved at the bare minimum in the design of these programs. The other aspect is with respect to the legal representation. Participation is not effective if legal representatives are not properly facilitated. Again, in Uganda, for example, out of the 4,100 victims, 2,500 opted for an external legal representative. However, according to the rules of the court can only provide legal aid to a common legal representative. So for a period of 1 year, the external legal representative used his modest resources to consult victims. Thanks to the concerted advocacy efforts of civil society and other actors, the registry was able to decide that they were going to grant legal aid to the external legal representatives. But again, this is not, the support that's been given is not adequate, because the external legal representatives haven't been able to effectively consult, to effectively meet with victims and inform them about the proceedings, which is absolutely crucial. Then we've also seen, for example, in the reparations processes in the DRC, in the Lubanga trial, which has taken quite a long period of time, there have been numerous consultations, some of them quite repetitive. And for victims, this process has been quite tiresome, because they've been interviewed by different consultants, some of them who have no knowledge about the context. So this in itself creates frustration. And then finally, the aspect of unmet expectations. In contexts where victims of atrocities have not received any form of support, that victims tend to have huge expectations on what the ICC can do to address their plight. Unfortunately, the ICC has also not been modest in informing the communities what it can and cannot deliver. So the court has to learn to manage the expectations by explaining from the start of intervening in a country its mandate to victims' communities. For example, what it can do and what it cannot do as a court. This should not be left as an afterthought and addressed only following obstacles that are encountered in a particular case. For example, the Kenyan experience shows that it's never too early to broach the discussion on reparations. I'll leave that at that. I'll make follow-up comments.
Thanks a lot. I think that now I listened with very big ears, because that's really immediately relevant for us at the ICC to hear how things happen on the ground and how we as the court are perceived on the ground. So very instructive. Thanks a lot. And now, last but not least, to Fiona McKay and her vision of how things have evolved. Thank you very much.
Thank you, Philipp. So I've been asked to talk about what has changed regarding victims' rights in the last 10 years. And I'm not interpreting that as limited to victim participation in the ICC. And I think broadly, I'd say that in the last 10 years, the biggest changes have really taken place in practice rather than in the development of new norms and standards. Because there haven't been too many developments in the last 10 years in terms of the main reference documents that set out victims' rights in international criminal law. In that regard, I would like to recognise the important contribution of Sharif Bassiouni in the elaboration of the UN Basic Principles and Guidelines on the right to a remedy and reparations for victims of gross violations, who of course sadly died this year. So I'm going to focus on developments in practice. And I will start by talking a little bit about participation of victims in ICC proceedings and reparations, following on from the previous presentations, to try to give a little bit the 10-year perspective. And really from the point of view of what was happening, I would say, more from the institution's point of view than what we've just very eloquently heard described in terms of the impact on the ground. Because I'd really say that from the ICC's point of view, in the last 10 years, the participation of victims in the proceedings became, if you like, normalized. The first trial chamber decision, detailed decision on victim participation was January 2008, so less than 10 years ago just, in the Lubanga case. And setting out the criteria for victims to be accepted as participants, defining the role that they could play in the proceedings and things. And at that time, there were only about 90 victims that participated in that trial. Then came the Bemba case, where there were more than 5,000 victims who came forward to participate. So what I want to say really in that is that in that regard is that of course the provisions in the statute on victim participation, extremely challenging to put into practice, as we've heard. But I think many people 10 years ago thought that it wasn't going to work. And especially people like me who come from a common law background, extremely challenging, because this is something that, we just don't encounter in our legal systems. Certainly 10 years ago, there was a fear of the numbers, that the sheer number of victims would overwhelm the court, that it would cost too much to manage the whole process. It wouldn't be viable to have victims participate meaningfully. It would encroach too much on the rights of the defence. These are all the things that we heard 10 years ago and further back. But I do think that in the last 10 years, it has been shown, with all the problems and things along the way, difficult learning experiences, that victim participation, even in quite large numbers, can be managed through efficient and streamlined application processes, common legal representation, that it can be meaningful with good legal representation and outreach, and that it can be effectively managed in the courtroom so that it doesn't slow down the proceedings or undermine defence rights, and that it can make a valuable contribution to the process. And I would say none of that was evident 10 years ago, and the fact that it does seem normal now to have victims participating in ICC proceedings, at least, is a sign of the strengthening of victims' rights in that regard. And I found it extremely interesting to see that even in common law systems, elements of victim participation have been introduced at the national level. In Uganda, as Sarah mentioned, and also in Kenya, there's a really interesting Victim Protection Act from 2014 that introduces some elements there. A very quick word about reparation, just to say that in 10 years, I think the progress has been much less. Of course, that's partly a matter of timing. A reparation only comes at the end of a trial and where there's been a conviction, and we haven't had very many that have got to that stage yet. There hasn't been too much time for trial and error. But just to say in general that there is, of course, plenty of experience globally on reparations for serious human rights violations. But really in terms of international criminal tribunals, it really is still very much in its infancy. And really only the ICC, as I think has been said, has really even tried to tackle it. And I would say has made a rather tentative start. But I would say that with the recent Al Mahdi decision, I really hope that it's on a better path. But when talking about victims' rights in criminal proceedings for mass crimes, I do want to say something about domestic criminal justice processes. And again, here I would say that developments have been largely in the practice rather than in the development of norms, although, of course, the process whereby more and more states have gone through incorporating Rome Statute crimes into their law so that they can be prosecuted domestically has been really important in strengthening the legal tools that are available to victims in many countries. Because in theory, victims of mass crimes, as victims of any crime, have opportunities in most legal systems to try to initiate an investigation or a prosecution. Exactly how these victim access to justice mechanisms work varies a lot from one country to another. So, in some countries, victims can actually trigger judicial investigations. Elsewhere, they can bring private prosecutions or challenges to the state's failure to prosecute. Or there can be a variety of administrative law or constitutional law remedies. So, in theory, there's usually something that people can try and use. Of course, where atrocity crimes are committed, the first duty is on the state to investigate and prosecute. Unfortunately, this isn't always, they don't always do so. But fortunately, there are many courageous and determined victims and civil society actors out there who keep pushing to make it happen. And when that does happen, you might think that it's just the state doing its duty. But if you look closely, you see that it is almost always the exercise of these victim access to justice tools supported by civil society that make this happen. And I don't want to paint a really too rosy a picture because, of course, there are so many instances where people struggle to get these things off the ground or you get an investigation, but then it's stalled. But I think that just stepping back and looking at it broadly, you see a lot more confident and widespread attempts to use these tools. And I think it's very important that success stories in one place can be really important in encouraging people elsewhere as well. I'd like to finish by posing a question. The Nuremberg Declaration calls for a victim-centered approach. My question is, what does this mean in the context of criminal justice for mass violations? Why do I ask this question? I believe, of course, that it is really important to listen to victims' concerns, take them into account where possible and appropriate, and really importantly, to explain choices that are made. But I see the risk that we're actually giving mixed messages to victims in the way that we talk about their role in the process, and unintentionally overpromising and creating frustration. So when we say, for example, as I hear often, international justice, it's for the victims, we want to give victims a voice, put them at the center of things, give them a sense of ownership in the process. I think we really need to think about how that will be heard and understood on the other side. Does it, for example, give the impression that victims are somehow going to be able to determine what is the scope of a case or who will be prosecuted? So I think that we need to be really careful. You hear victims saying, for example, they get frustrated. You hear the frustration, and I've heard just a couple of examples. Why does the accused have more rights than the victims? Well, of course, this is a criminal court, but that is the question that I've heard asked. Or, why is the court only investigating some incidents and not those that I want them to pursue? And maybe those that I told them that I wanted to pursue. It really raises questions of credibility, I think, if the rhetoric doesn't reflect the reality. And of course, this situation is not only as a result of the kinds of statements that I mentioned, and it is really hard to explain the complexities of how the ICC works. But I just think we need to be more thoughtful and meaningful and not overpromise. Which conveniently brings me back to the question of, broadly what's changed over the last 10 years, to highlight the vital importance of different types of communication with affected communities. And I am happy to say that I think it is hard to imagine now that a new international or internationalized criminal tribunal could be set up that didn't include an element of outreach and public information. So I think that has to be seen as an important evolution. Thank you.
Thanks a lot. A cautious positive note and a question that I think will be for all of us to speak to. Are we not overpromising with what we're putting into not just the Rome Statute, but all the statutes that we're creating, where oftentimes things are just being copied and pasted from the Rome Statute into the other statutes without necessarily maybe having exactly that reflection. I would like to come back to your respective remarks before we open the floor with one quick question from my end. And my first one would go back to you, Judge, and that's really from your perspective, from the judicial end of things. What were the main challenges that you were looking at in pioneering the Rome Statute in action, and do you think that these challenges have been met? Did you tick the box, so to speak, as the judges?
Thank you for the question. I remember that at the beginning, all judges were very excited with this victim participation because it was big novelty and very important, of course. And when we worked out the regulations of the court and other concepts, we were, in good sense, naive, not seeing ahead of these challenges. What I mentioned about memo of Judge Cowell, for example, he already had concerns, but for us it was very important to fix it in regulations of the court or other bylaws. And of course, when we had first experience with first cases, we understood that it's not so easy. It's so many problems we are facing. And I remember that in the confirmation of charges, Gujula and Katanga, I was also very excited when counsel represent victims, some victims, and what I heard in presentation only history of Congo in that time. So it's of course question of quality of this representation. What we want from this representation? Do we want numbers, 13,000 or more, or we want something different, that these people were represented and were heard? And of course, this concerns about the principle of equality of harms. I would say that in my experience in appeal chamber, all filings of victims representative, they actually were in the same lines like prosecution. And so I think something is missing, still missing. Of course, I am from 2015, I am out of the court, but my feeling is something missing, is something not yet developed in this victim representation, how it will be really meaningful, genuine, effective, not prolonging court proceedings, not so costly. And so I think it's still a lot of challenges ahead. And yeah, here I stop.
Thank you very much, Judge. That's quite insightful. Yeah, a lot to chew on. Sarah, just coming back to your submissions and also the practical challenges that you indicated for the field. What I'd like to ask you is the simple question: if you look at the big picture as to not just the problems we have in the field, but also how it works back in the courtroom, the simple question: did the ICC get it right in principle, in terms of is the legal framework as such at least sound, and is the role of the victims properly outlined? Now, leaving aside the challenges that you've mentioned in the field. So, did the court get something right?
At the starting point, the inclusion of victims' participation is, the court got it right from that point, having that as enshrined in the Rome Statute, and then enshrined in the rules of procedure, and then having the courts provide jurisprudence that really elaborates what the content of this right is. But as we've seen, there's been inconsistent application regarding the extent of victim participation. The court has issued decisions where it seems at some point to broaden, at another point to limit. So I think this is an area that is still evolving, and we hope that at some point the ICC's jurisprudence itself will clearly earmark the nature of participation, so that at least victims and their legal representatives have a clear understanding of what to expect. Right now, it seems to be a bit of lack of that.
Thanks a lot. And this brings me to my question for Fiona. After now that the ideas that you've mentioned in terms of your assessment of the last 10 years, what would you want to see as further developments and changes, and what do you think we're likely to see in the general confines in which you've taken the topic?
If it's all right with you, I'm going to choose to answer the first part. What do I want to see, and make my wish list rather than try to gaze into a crystal ball and become overwhelmed with all the challenges and obstacles. No, I would just mention reparations. I would really like to see a way forward so that reparations, which up until now has really largely been developed in the context of state responsibility, we can really have a clear framework and a way for criminal tribunals to deal with reparations for mass crimes, but without going down the road of a heavy individual claims, judicially determined claims process. And I'd really like to see that, because I think that once that is accomplished, then it could be a model for others to follow as well. And I think people are looking to the ICC to establish that framework, and I'd really like to see it do that well.
Thanks a lot. This brings us to the point where we're opening the floor for questions. I would say maybe we take 3 questions at a time, and then we have the panelists react to that. I have Steve? Chris, yeah, go for it.
Thank you. Thank you for these great presentations, and insightful, also critical perspectives. I'm interested in the comment about, or the enthusiasm necessarily, for civil society-led victim participation. And I have a question about the efficacy and security sensitivity of that and how the court manages that dynamic. And you mentioned Kenya in your remarks, and I thought that was quite an instructive one, right? Because you had the Kenya National Commission for Human Rights first, investigate crimes there, and then their witnesses started, getting targeted, and then the Judicial Commission of Inquiry, using many of the same data points and their witnesses, and then even the Special Rapporteur for Extrajudicial Killings going up and going and visiting witnesses, and then the ICC comes. And basically every actor all along the way made significant misjudgments, right, about the security implications of their own conduct in that situation, with significant consequences for victims. So how do you, what do you propose, maybe for you add to your wish list, in terms of how the court goes about engaging with civil society, perhaps to either upskill them or even warn them off, right? Because often these can be victims themselves can lead these or demand in investigations, even start being vocal about things that have happened to themselves. How does the court, how could it use its own analysis of a situation to sensitize either people advocating for victims or victims themselves to the consequences of their public engagement or the launching of any kind of investigation?
Thanks. I forgot to say, when you take the floor, please also name your affiliation and name. This was Chris Mahoney, Center for International Law Research and Policy. Mark, there's the next one.
Thanks, Mark Kirsten from the YAMO Foundation. I have a question about reparations, and I suppose it goes to what they're intended to achieve. And you mentioned the Almaty ruling on reparations, which I find particularly interesting because of its reference to reparations as a form of deterrence. There seems to be this acknowledgement, I think it's in Katanga too, that reparations can have a deterrent impact, which goes to peace and justice, and that these perpetrators literally have to pay, and that'll help deter these crimes. But some people have raised the issue that maybe that shouldn't necessarily be the case, right? Reparations are about repairing the damage or the harm done to victims, and that should be its focus, not a kind of cost-benefit analysis which says, well, there's this much in reparations that'll hurt the perpetrator this much, that'll ensure that they never or no one else ever perpetrates these crimes again. There seem to be competing kinds of interpretations of what the impact of reparations is supposed to be. So I guess my question is, how can the court, moving forward in developing a stronger reparations record, ensure that those two kind of outcomes or goals are complementary? Thanks.
Hi, my name is Marieke Wierda. I work with the Dutch Ministry for Foreign Affairs. And my question is for Sarah, because in Uganda we have a very interesting situation of domestic prosecution and an ICC prosecution proceeding simultaneously. And can you maybe reflect on what are the pros and cons for victims and affected communities of both of these models? Literally, which has more access, which will have more impact, which has more interest, because I think it will enable for an interesting compare and contrast.
Thanks a lot. Maybe now a good moment for our panelists to come back. Shall we start from the far left, or for the spectators from the right?
Thank you, Marieke, for that question. For the affected communities, one of the challenges these concurrent proceedings have presented is a level of confusion about in terms of jurisdiction and in terms of what the two jurisdictions can provide. One of the limitations has been the inadequate outreach by the International Crimes Division. So we find there's been a conflation of roles. So when they go to the communities, there's an assumption that this is the International Criminal Court. And the other unfortunate part is that the ICC outreach unit and the ICD have not conducted joint outreaches to create further understanding of their distinct jurisdiction and distinct mandates. And this is one of the areas that we think it's critical that the court should at all times create awareness about its complementary role, and by doing so, work with local justice mechanisms to reach out to communities, raise awareness about this, while at the same time empowering these communities, these national jurisdictions. Now, the other challenge we've seen is with respect to resources. For example, the victims in the Koyolo case are not receiving as much support and resources and are not getting timely information, as we've seen in the case of victims in the Ongwen case, where there's been an elaborate, much as it is not to the best of the satisfaction, but at least there's been an effort for the legal representatives for victims to constantly reach out to their clients and raise awareness. However, this has been lacking with respect to the Koyolo case. And obviously, when you see that the Ongwen case has now advanced, we have almost 34 witnesses who have testified, whereas the Koyolo case, which has been going on since 2011, is still at the pre-trial phase. There's that level of frustration, and yet you're seeing these are victims in the same community. These are victims who suffered more or less the same harm. They do not understand the distinction of jurisdiction. They understand that international criminal justice is here to deliver justice to us, and it should be done in a timely manner. So what we're seeing actually is now a creation of hierarchy of victims, whereby you have the victims in the Ongwen case who have some level of assistance and support, and you have the victims in the Koyolo case who really do not have much, and their legal representatives are not well facilitated. Thanks.
Thank you. So on the first question about civil society and security is what I understood. And the questions about the ICC, yeah? Because I think when I was talking about civil society, I was mainly talking about domestic, instigating domestic proceedings, but it's a fair question. And I would say that when you talk about the role of civil society in supporting victims in ICC participation, it was a huge challenge for the court, and I think first of all, the principle was established in the decision in the Lubanga case that the court should be responsible for any security concern that arose out of interaction with the court, people's interaction with the court. So that was the principle. But the ICC really struggled with that, to actually make that happen and to go beyond actively providing any kind of protection beyond, other than to obviously to witnesses and to its own staff. And that was always a tension and an issue, and I'm not quite sure whether there's been any progress on that, and it would certainly be on my wish list for that to be resolved. I would say, though, at the end of the day, and thinking about some specific examples, because when I was at the court, we really did try to sensitize local civil society, and sometimes we'd be saying to them, well, you might not think that there's a risk, but actually we think there could be. At the end of the day, people are free agents, and that there are limits to what you can really do beyond suggesting. On the second question on reparations and what was said in the Al-Mahdi decision about reparations being a form of deterrence. It's interesting because I think the same thing came up actually in Lubanga, the trial chamber, and its decision on reparation was really really talked a lot about trying to deter use of child soldiers in the future. So it was very strong there as well. And the principles and guidelines on reparation that I mentioned, the Van Boven-Bassiouni principles, do say that one of the forms of reparation is guarantees of non-repetition, to try to stop the same thing from happening in the future. So that is, if you like, part of the notion of reparation and the purposes of reparation, at least from that broad legal framework. But I understand your question is more about on the ground. If people, it doesn't seem relevant to people because they have competing interest there. And I think the thing I would say is that I don't see why they should necessarily have to be competing. That I think you should aim for both, and that primarily reparations should have the reparative goal. But I don't see why they shouldn't also aim, if appropriate and if it's feasible, to try to deter the violations happening. So I don't see why they would normally be in competition. But I would say, though, just a quick footnote on that, because it is true that in the Lubanga context, for example, in Eastern Congo, it's absolutely, I wouldn't say it's the thing that resonated. You did feel a little bit as if the court was trying to preach to the people and say, look, we want to tell you that this decision is telling you that you shouldn't be using child soldiers, and it wasn't something that was coming from the community. It wasn't a request that reparations should include that. That's certainly true. But I don't think that necessarily means that it's competing.
I would like maybe a little bit to elaborate of victims' participation regarding outreach programs. Because in my view, outreach program has the goal not only bring more witnesses to the court. I think in this outreach program, victims should be, I would say, educated about importance to build civil society, to have state which abides the law, where human rights are respected. And then at the day, if the progress will be in these transitional societies, then also it will be economic improvement, because it would be more safe environment to attract funds. And the next generation will live better than the victims. I think it's very important to understand, because not to live today to receive some reparation for damage or harm, but to explain this deterrence, how it's important for future to build civil society. Thank you.
Thank you very much. Next round of questions. All the way in the back, gentleman with the glasses.
Yeah, thank you very much. Andreas Schüler, the European Center for Constitution and Human Rights. And my question goes a bit beyond what you discussed on the panel, or maybe it's also only a comment on victims outside the ICC system, basically. So those from Syria, from Iraq, from Sri Lanka, from Chechnya, or many other countries living here in Germany and elsewhere. So what could be answers for them? What criminal justice or international criminal justice could do for them, or how this could be used in if we talk about needs of victims. So those are questions we are always challenged with, or especially if the ICC is not an option for them. And so I'd like to broaden it here, but of course, giving also the composition of the panel, I don't expect full answers on that if that goes too broadly on the victims' participation in the ICC, of course. But wanted to raise the question, to bring it in, what can international justice offer those who are not in the ICC jurisdiction, basically. Thank you.
Thanks a lot. Here we have the gentleman over here.
Gentleman is perhaps an exaggeration. Michael Hartman, I have spent the last 10 years or so in Afghanistan with the UN. Very briefly, I respectfully disagree with Fiona and others on reparations. Reparations and fines are different things. If I want to, as a judge, and I'm a prosecutor all my life, so that's what I ask for, if I want a judge to deter someone from doing something, then there is the threat of jail as an example, and there's also monetary fines or punishment. As far as I am aware, that's far different than compensation for damages or reparations. If you are a judge, how do you determine, and when you say they're not in conflict, I think they are, because a judge looks at the evidence of what the damages were and then can decide what the reparation can be. If a judge tries to figure out how are we going to come up with a general deterrence that will deter not just this gentleman or lady, mostly gentlemen, who are in jail anyway, but send a message to the rest of the society, that's far more amorphous. And those are two separate decision-making processes. So I suggest you need to keep them separate. And a second point where there was a question or a statement about it seems that some of the victims are not getting as much support at the domestic system. My experience overseas has only been in domestic systems as a prosecutor for the UN in Kosovo and also working in other places. And that's just the way it is. I think we have to be realistic. When you're talking about the ICC, you are going to have a lot more money and a lot more resources for victims than generally developing third world post or current conflict countries where they just don't have enough money and where generally you can't even get a defense attorney for a murder case. So if you can't get or pay a public defender or legal aid for a murder or war crimes case or having problems, then unfortunately you're going to have less. And that's just a reality. Thank you very much.
Thanks a lot. A statement. Let's take another question. The lady with the glasses in the middle.
Thank you very much for this very interesting panel. My name is Inga Kravchik. I'm from the PhD program Human Rights Under Pressure at the Free University in Berlin. And I have a question to all of you, probably with regards to the participation of victims of sexual violence in the proceedings and to the potential which it bears to re-traumatize those victims. You mentioned the Katanga case. If I'm not mistaken, it was the first case at the ICC where charges of sexual violence were brought by the prosecution and were also confirmed by the pretrial chamber. But in the end, Katanga was not convicted for those charges. So it probably means that the victims were also not entitled to the reparations. So the question is there actually a need for physical participation of victims of sexual violence in the proceedings if in the end of the day the question is to prove the link between those responsible and the acts which were committed? Thank you very much.
Thank you very much. Since we had two questions and a statement, I think we can do another question. I don't see anybody now. Then David Scheffer. Thank you.
Dave Scheffer from Northwestern University. Just following up on Mark's statement, I'll ask the question. Perhaps this really goes to you, Philipp, and maybe Fiona, from your experience with the Victim Participation Division. Can you give us an update on the degree to which you are generating necessary funding for the victims. Obviously, the Victims' Trust Fund is the key point here, but from your perspective working within the court, where are we today, and how much further do we need to go in order to at least provide the resources for the ICC, which is, of course, the separate point from what Mark was raising, which is at the domestic level, so much resources is needed. But if someone could update us on that, that would be very helpful.
Thank you for this. I would say, who wants to go first?
I'll start with a question from the gentleman in the back regarding what can be done for victims who are not within the ICC jurisdiction. And obviously, the ICC is not the only player within the international criminal justice landscape, but we've seen from experiences of victims of past atrocities, a very good example is the experience of victims of the Hissène Habré crimes in Chad. With the support of Human Rights Watch and other civil society actors, we saw how they were able to document, preserve information, and advocate for justice. I strongly believe that victims of the Syrian crisis do have a role to play in that and should be supported in terms of documenting their experiences, documenting the harms that they suffered and the impact of these violations. And as we know, that regardless of the current political stalemate, global political inaction, eventually this information will be useful. I mean, the Chad situation was way back in 1992, and we're seeing a conviction was issued last year in 2016. So I am a bit optimistic about the possibility of having these perpetrators eventually brought to book, and to do so we need to have this information and evidence preserved. Now I'd like to make just a comment on the comment. Yes, obviously we cannot compare the resources of the International Criminal Court to domestic jurisdictions, but there are certain minimum expectations that these jurisdictions should be able to provide that are not resource intensive. For example, aspects of outreach, aspects of public information, and this is where, to me, positive complementarity becomes key. The court supporting the national jurisdictions, not in terms of providing resources, but in terms of technical capacity to set up frameworks that are appropriate within their context to provide information to victims, to provide a level of support, again, within their means to victims. So I do not necessarily agree that because we have this disparity of resources, then we should say, well, the minimum, we cannot meet even the bare minimum expectations. Thanks.
Thank you, and completely agree. And just to add on the first question on the what can the victims of Syria, etc., who are in Germany do. Actually, Germany has been one of the states, you may be aware, that has proceeded to bring proceedings on the basis of universal jurisdiction against the senior Syrian regime leadership. Of course, the cases are open, but there are no there's nobody in the courtroom yet. But certainly, a number of states, and Germany among them, is making who have specialist war crimes units that are responding to victims who within their countries who go and say, look, you know, there are victims in this country, in a number of European countries that are victims of crimes elsewhere, and asking the national authorities to investigate and initiate prosecutions on the basis of universal jurisdiction. There's also the AAAM. You talked about the importance of evidence preservation. There's this new body that's been established recently by the UN that specifically for the purposes of preserving evidence in relation to Syria. It's really early, it's only just starting up now, so I'm not sure yet to what extent it's going to be, for example, receiving information from exactly how it's going to work, you know, from individual refugees in different countries. But do watch out for that, because I think in the new year they're going to start more actively their operations, and hopefully it'll be made. The information will be made available on how to access that. Yeah, on the statement, I'm afraid I still don't understand how why reparations and the deterrence and reparative sides would need to necessarily be in conflict. I understand they're separate. I don't see why they need to be in conflict, but I'm prepared to accept that it could be my failure to understand. On the update on funding for the trust fund, I think essentially the trust fund for victims receives the contributions, voluntary contributions from states, often around this time of year, because states like to look good at the annual Assembly of States parties that's coming up at the end of the year. And my view is that if they want to become bigger than they are, I think they've got something like sort of 3 or 5 million euros, something like that. I'm looking at Philipp, who may have, in that kind of ballpark anyway. If they want to significantly increase that, I think that resources need to be put into fundraising. You know, you don't just sit there and people give you funds. You need to go out and fundraise. So, but it's that, I think that's where it is at the moment, and hopefully they will be. I understood at one point the trust fund was talking of having a fundraiser and things. I'm not sure, but you can clarify. Fantastic. Just on the question of victims of sexual violence, are you saying that if the charges aren't going to be made out in the end, if charges of sexual violence are brought, but the person at the end of the day is not convicted, then should people really be giving evidence along the way? Or I wasn't sure whether you were saying the opposite, and maybe there should be more evidence brought in order to secure conviction for those charges. Is that?
The question behind is whether there is actually a necessity to challenge victims of sexual violence with re-traumatization during the proceedings by their participation in the proceedings, if in the end of the day it is even not guaranteed that they will be entitled to the reparations. And also if the need is actually to show the link between the responsible and the acts.
Well, that's really easy in the sense that participation in proceedings is completely voluntary. So, okay, on the one side, you know, there may be victims of sexual violence may be called to testify, to give evidence in the case, and that's up to the prosecutor. But participation in the proceedings is completely voluntary. And I know I may not be up to date, but I know that the court tries to work very closely with women's organisations and with people who are close to the victims in order to make sure that it's clear to people that it is voluntary, and that Philipp's nodding, and to also to work with local groups to make sure that, as far as possible, if people do want to apply to participate, then you avoid that re-traumatization.
Regarding victims of sexual violence, it's in the case of Ngujula and Katanga. When we confirmed charges, I wrote dissenting opinion regarding sexual crimes. I disagree with my two colleagues that there is enough evidence for these crimes. Of course, I was in minority. Then, of course, case went to trial chamber, and trial chamber was again faced with evidence, and this is a problem in ICC. Evidence. It's not enough evidence, because the standard of rights of accused are very high and rely only on, let's say, reports of NGOs or something. It's not enough, and it's always, we need to decide what we want, fair trial, or we want historical record. And it's in the domain of prosecutor to bring good evidence. I hope that in the future cases it will be more successful. And then regarding these victims who are now living in Germany or in other countries as judge, I would say that how we are using a word victim in legal sense or in everyday life, yeah, it's very important. Of course, many people who flew to Europe, they think they are victims and they went through terrible events. I would say that we need to explain them what is the status of victims in legal proceedings. If we don't have legal proceedings for different reasons in this complicated situation, for example with Syria, what we need to do to just ask these people to make a record, to write about their experiences, because maybe time will come and these testimonies will be very important. And regarding Syria, it already was mentioned that special body is established, and I recollect that in one of the prisons in Syria, women were raped, and some of them escaped. And then, of course, doctors help them, and there is very reliable evidence of these crimes. Only question is what it will be used. But of course, evidence should be fixed. Thank you.
Thank you. And I take the liberty to quickly respond to David as well. I think that the funds of the trust fund have gone down in the nearer past, for the simple reason that the general situation has been such that many states have stayed away from making continuous contributions. So I think they are in need of further contributions, and they react to this, indeed, exactly as Fiona said, in now hiring a fundraising officer, which would take care of that part of it much more professionally. What does the court do? Obviously, the court has no immediate role in this, but what the principals of the court do is whenever they do have the chance to make any public speaking engagements, they would underline the partnership in the in the ICC system, that the trust fund is part of that ICC system, and therefore it is actually quite helpful if states were to not just think about the ICC and the assessed contribution side of it, but also the trust fund is something that sort of needs additional funds and thought. And lastly, recently one of our field offices has actually generated some voluntary funding from a state party that was really due to an activity that was carried out by that field office, Kampala. And that is actually something which could also be an interesting model. However, the funds that are generated in these confines are obviously negligible compared to what is actually required in order to get the reparations and assistance mandate system going as it is constructed by states parties in the trust fund. And this brings me to the next and last round of questions, if there are any left. And I see that people really want to have coffee. Excellent. In this case, please join me in one big applause for these great panelists.